Okay. Okay. So Jeff is a very tough act to follow. He was a fantastic speaker, and I won't bore you with the details of how I got everybody killed in both Las Vegas and the tribe with my negotiation. But I thought the way RTI has arranged this makes a lot of sense, because Jeff was talking about creative agreements and being able to set emotion aside, and that's really the topic for this panel as well. As Ted mentioned, we get into our kind of trained habits of thought based on where we fall relative to the V. Some of us are always representing plaintiffs, some of us are almost always representing defendants, and then of course they're the insurers who have to ultimately pay. And so through our training, our education, our experience, we get in these ingrained habits of thinking that the V is kind of the demilitarized zone, and on either side all of the guns are facing each other. And from the defendants, of course, you always have the thought of cross claims and third-party claims, but how often do we really stop to think about whether we should actually collaborate with the plaintiff? And again, it kind of violates a lot of our ingrained habits of thought, and it kind of brings to mind kind of one of the words of the year, which is collusion. That's what we're really talking about here, is colluding with the enemy, and the strategic considerations that might make us want to do that in a certain case, and then what might be the advantages and disadvantages of the approach. And we're going to be talking about all of these issues with very experienced counsel on both sides of the V, and with Tracy Steele representing the insurance side of things, and also looking at how does it impact the defendant who's left out in the cold when one or more defendants cooperate and collaborate with the plaintiff. And what are the different strategic considerations in terms of whether you enter into one of these agreements. And of course, we'll be talking about Mary Carter agreements and the different forms that they can take. And maybe from time to time we'll also poll the audience just to see what everybody's experience has been in terms of whether you've been in the role of the collaborator, whether you've been in the role of the target non-settling defendant, just to see what everybody's experience has been in this area. I guess I'd like to start with a real general question, which is that because we're used to representing, in the case of Brian, representing people who have lost their lives, who have been horribly injured, and you get used and trained into the plaintiff mindset, or in the case of a defendant, you're used to thinking of claims of being exaggerated liability and exaggerated damages. So the first question I have really for everybody on the panel is, what is your general attitude and philosophy in terms of thinking about, do you actually collaborate with one or more entities across the V? And the first person I want to turn to here is Brian Alexander, because as I mentioned, he's representing people who have lost their lives, who have been horribly injured. There's a lot of emotion involved, and they've identified the parties that they think are responsible for this. And then he makes the phone call and to have this conversation about kind of going lightly on one or more of these entities for strategic considerations. And so it might cause a little bit of cognitive dissonance there for you, and I'm just kind of wondering what your general attitude and philosophy towards that is.
First of all, let me start by just thanking RTI, thanking Joe and Ted, Steve again for your hospitality. I want to thank Morgan for filling in as our moderator very much last minute. We had some casualties because of the weather. And for, frankly, half of our panel jumping in here. We were lacking a defense perspective, although I'm sure Tracy could have done it.
Ashby and Rick did not make the PowerPoint there, so yeah.
We'll get over it. But, so the first rule is to not answer the question you've been asked. So I'm going to start actually with what was on my mind when we kind of came up with this concept. And Tracy and I, it was a direct result of a case we were working on, which I'll let her speak to directly. But in my mind, when we had gotten through this, and it was a case that actually involved the Mary Carter agreement, a unique one, I think, and it very much involved, more than maybe any other case I've actually worked on, a real concerted, unified effort by the plaintiff and her insured for a number of reasons to pursue, in this case, and quite not surprisingly, an aviation manufacturer, a helicopter manufacturer in that case. But I want to start with the first case, the war story part of all this, that I encountered where it was really shocking to me, the strange Bedfellows concept. I kept saying to myself, I can't believe were in bed in this case with KAL, and I'm talking about a nearly 21-year-old case now, the KL 801 crash, which I'll just spend a minute. I'll give you the conclusion first and then give you some of the facts real quick if you don't remember it. But the conclusion, the take is just the surprise that we felt when we learned of it and all along the way that KL, the airline, and the FAA, who was responsible for controlling the aircraft at the time of the crash, were unable to do what we see so often, which is to work out a sharing agreement, to come to terms or agree to come to terms later, and then go after the plaintiffs hard on some very, very important choice of law issues, which they could have stacked the deck on us, and some damages issues, which they could have stacked the deck on us in a unified way. They chose not to do that, and even to this day, it's a bit of a mystery as to how that happened. So one of the things is that the plaintiffs don't always know how you come to that point of having to make an election to work in a particular way against one of the defendants. So just recall, 801 is a crash in Guam. It's a classic Boeing 747. It's loaded up. There's almost 260 people on it. It ends up ultimately crashing into Nimitz Hill in Guam. There's plaintiffs on board or passengers rather, from the United States, from Guam, from Korea, and a couple other countries. The flight crew, notably, there's a very seasoned PIC on board. They're a all-Korean crew. There's a junior co-pilot on board. That becomes relevant a little bit later. So you had a ranking member and a junior member. The weather was terrible. Fog, IFR conditions, low ceilings, nighttime. And what was really important was the approach. Okay, the approach, first step, it's always dominoes, right? I've given you a couple already. Bad weather, we've got a crew mix issue. Next thing is the approach itself. The ILS system is out, okay? If you know anything, we've seen a few of these. The Asiana crash comes to mind. For whatever reason, certain crews really get locked into automation and really get locked into certain types of comfortable approaches. The ILS certainly is one of them back in the day. This is the 90s. That was out, so this crew immediately starts to have the deck stacked a little bit against them. Next thing was, it was a VOR, but it wasn't just any VOR. What's normal for someone like Justin Green was not really the kind of thing that these guys might face, being a VOR step-down approach. It wasn't direct, kind of a tractor beam to the end of the runway. And oh, by the way, the VOR was not on the end of the runway. It was misplaced several miles away on top of Nimitz Hill. So the crew was dealing with that. It was a little unusual for that type of approach, and even more unusual to have to do it into Guam, where they always had flown the ILS approach. So you had the approach as a domino. And of course, they were task saturated. It was raining hard and on and on and on. So what happens? The step-down approach basically, in accordance with the DME, the distance measuring equipment, just gives the crew steps at various miles at altitudes they cannot go below. One of those steps is right over Nimitz Hill, sufficient clearance before they go then all the way down to the runway. In this particular case, they missed a step, they crash, and 228 people die. The other thing that I mentioned was the rank of the people in the cockpit. The NTSB developed the cultural problems of the junior officer who really knew they were making a mistake, not speaking up to tell the pilot what was going on, and as a result, the accident happened. So what do we conclude? Absolute slam dunk, pilot error, all KAL, rip the knob off, walk away, pay me, okay? That's the position we take. But not so fast. Fairly soon after, the rest of the case is developed, the case against the FAA. And that domino basically boils down to two things. One, the aircraft was being monitored at all times by air traffic control and a private tower. And if you're monitoring an aircraft, you have a fundamental requirement. Some would say priority number one. You have to give a safety alert. No safety alert was given as a direct result of unbelievable negligence by the air traffic controller. Basically monitoring without monitoring, meaning not at the scope, not paying attention, with nothing, and I do mean absolutely nothing else going on within thousands of miles of this aircraft. This is like 2 in the morning. Second thing is, and even more damning for the FAA at the end of the day, was there's a system called the Minimum Safe Altitude Warning System. It's a computer algorithm system. It's designed to put a tractor beam basically below the VOR flight path to tell the controller with both an oral and a visual flashing alarm that the aircraft is on a rate of descent and at an angle at which it will encounter dangerous terrain. What happened there? No alarms. Why? In their infinite lack of wisdom, the FAA, through their people on Guam, had decided to disable that system. Knowingly decided to disable that system. Why? It was a nuisance. It was going off too often. So rather than fix it, they shut it off. That's what happened. So how do we get to strange bedfellows? Well, KAL, recognizing they were in deep trouble, recognizing they had at least a little bit of a case against the FAA, went to them. And again, in their unbelievable, infinite lack of wisdom, the FAA as a client and the DOJ as attorneys decided not to pursue a deal with them. And we understand that the deal was, hey, how about a 90-10 split? How about maybe an 80-20 split? Somewhere in between there was the place that they were trying to negotiate. There were a few FAA attorneys, or DOJ attorneys rather, that thought maybe that was a good deal, let's grab it and run. But there were others that said, no way, there's really no negligence here. KL's conduct is egregious, and on the MSAW thing, we'll probably get discretionary function because we had a good reason for turning it off. Fast forward, what does KL do? They come to the Plaintiff Steering Committee, and they say, hey, we want to work with you. We're going to pay you. We're going to pay you, but we want to work with you to bring the United States to the table, to really hammer these guys so that their contribution goes up and our contribution goes down. And if you do that, we didn't have any Mary Carter. There was no deal. But if you do that, there's other issues that we can help you on. And that was basically a wink-wink to, we'll pay you better damages than you would otherwise get, particularly for those cases that might be subjected to Korean law damages as opposed to U.S. law. So in conclusion on this case, what we then did was accept their invitation, join forces with KL and their attorneys, which was Condon and Forsyth out of L.A. And it was really an extraordinary team effort to pursue the United States and develop this discovery and go after the witnesses in a unified way, go after the discovery in a unified way. And unlike the case that Tracy and I worked on, which we'll hear about in a few minutes, what was great about this was that it happened after we filed. And what it allowed us to do, because everything was already set up in terms of case management, we basically could double dip. We got together on our cohesive strategy, but then we had twice as many witnesses that we could depose, twice as many requests for production that we could make, and interrogatories that could serve, because those things had been broken up between plaintiffs and defendants, even though that we were now working together. So it was a case where we were able to double dip and then strategically use the strengths of our firms, our committee in our case, and that firm to have the defendant set everything up for us in terms of getting things and authenticating records, and then we would come in and really put some blood on the table in terms of making the United States pay a price. So it was really an extraordinary first experience for me to see the benefits of coming together. It wasn't without some risk to us. KL could have any time, put some of these other issues on damages and choice of law on the table and against us, but because that effort was so successful and they saved so much money, they were willing to give up a little bit to us at the end of the day to maximize recovery for our clients. So,
and it was done without any written agreement whatsoever?
No written agreement whatsoever. It's not a Mary Carter, which we'll talk about later, so we didn't really notify the court. The United States certainly knew what was happening soon after it happened because it was so obvious. And at the end of the day, the pressure that was created was really what did, in fact, bring them to the table, did result in very excellent settlements for all the passengers, which is what you're trying to do in any event. And so that was my first foray into it. So in answer to your question, my 10-minute answer, is that it can be and often is a really great tool for the plaintiffs. And it's something that'll either fall in your lap or you can push some buttons to get you there. What's more fascinating to me is really the view of the others on the panel of why does this make sense for defendants or insurance companies? Why are you willing to take some of the risks that might be inherent in going down the road of working with the plaintiffs?
Oh, well, with that perfect moderator job, let's pass the mic to Ashby. And Ashby, can you speak to that? And then Rick?
Well, generally speaking, I'm against helping out the plaintiffs. That's in my bones. I don't want to be on. Can't help it. But it does happen. Whether you're representing a self-insured, you've got small policy limits, or you just really don't have any liability. There's a reason. For some reason, they're coming after you. Usually, when I've done it, it's involved of getting. We're sitting there with $100,000 policy limits. Our clients really underinsured. We've got to protect assets, and it's finding another entity to go after and get the plaintiff to go after. And doing that, I've had where 2 or 3 defendants worked with one plaintiff attorney to go get a $5 million policy. And then other times, it's usually falling into that category. And that's the reason we're just trying to get out and get the help that we can help the plaintiff let us out.
Okay. And Rick?
Yeah, I want to take a little background on this, first of all, because we work in a very unique industry in aviation law. And like I look at Brian, I look at Justin, I look at Dan, other people on the plaintiff's bar that are not here, and these are people I would always pick up the phone with. And it's just sort of the way we do things because of we know these people, we know we can work with them, and we often do have a separate agenda. Turn that around now. Multi-defendant litigation. For each party at that table, there is an insured, there is an insurer, there is a lead insurer, there is a broker, and there are piles of co-insurers, many of which overlap, and all of whom we as defense counsel want to be in their good graces. So we are really always being watched to some degree by the insurance market. And I'm going to tell you a story that has nothing to do with a case, but put things into perspective for me. And I apologize, it ends with an expletive, but it has no impact if I spare you the expletive. I had just opened my firm. It was about 2001, 2002. I went to London, and I thought I was the king of the world. I was a 30-something lawyer opening my new firm. I had work from London. I had a product integrity program I was running for what was then British Aerospace, soon to be BAE Systems. I had some carry-on work for my own firm. And I'm feeling great. And of course, with the time difference, about mid-afternoon or so, my then first-year associate, now my partner, Joy, calls me. And she says, Rick, how's it going? Oh, great, I have lunch with so-and-so and so-and-so. All these wonderful people are letting me buy them dinner, and give her this whole story. I'm feeling great. And then I get a call. Oh, Rick, listen, we have a conflict. So we can't do lunch, but we're open tomorrow. So I say, oh, here, look, I already have a lunch tomorrow. So I'm meeting with company X, and I'm meeting with an insurance company, and this call was from an insurance, and they're your insurance company anyway. So let's just have lunch together. Now remind yourself, this is London, a little different culture. What I had unintentionally done was set up a lunch with an insurer and their insured without the broker with me as an American lawyer. I tried to invite the broker, that got lost in the shuffle of things. About an hour later, I get called aside by a broker, ripped a new orifice for setting up this lunch without daring to set up this lunch without connecting and inviting him along. Joy, innocent as ever, has something to tell me about one of our cases. I'm fuming, I'm frustrated. She's just heard me give this glowing report. Rick, listen, I just want to talk to you about this one case. How's it going there? Lousy, Joy. It's a fucking minefield, is my response. So my point, though, is that these multiple relationships carry over to the litigation. And so what we need to be mindful, I think you're of the highest ethical principles if you can be fully mindful of only the party you represent without being mindful of who's watching. So therefore, while I would reach out to Brian or anybody else to try to do what's right for my client, I think a lot of us feel a little bit of a pressure to at least try to be transparent. Like if we're going to try to cut a deal with Brian and the plaintiffs, we might let it be known before we make the call that we're going to do that, so that we're not the sneaky guy who cut the deal. And because these things will come back to haunt us, and ultimately it's our reputation that means the most. I can think of one of the earliest cases I had with Kreinler was a helicopter accident in which it was very clear, very early on, that this was really a manufacturing case. I was in for another party, and the case went on for years, and basically we were tag-alongs. So we would have loved to have cut a deal with the plaintiffs to get out early, but sometimes joint and several liability and other aspects of the law make that impossible. But if I can get my client out, one of the typical deals I would offer is, look, what will you take to let me out? And what else do you need? Very often is, well, look, we need you in the case because we don't want an empty chair. Well, I'll accept service of a subpoena on behalf of my client, and we'll produce whatever witnesses you want at trial, so there'll be no empty chair. Sometimes that does the trick. But generally speaking, it's been my experience that most plaintiffs' firms are very, very disinclined to let out anybody piecemeal if they feel they have a reason to want to keep them in the case.
Okay, and I think you just touched on something that I wanted to ask Tracy about as well, which is the fact that this is a very small world, and we're running across the same brokers, the same defendants are oftentimes co-defendants in a case. We frequently see the same plaintiffs' lawyers, we see the same insurers. So in a small world where there are so many repeat players and we have to deal with people time and again, that can have an influence on how we act in any one individual case, and I think that's of special importance for the insurer. And so Tracy, what is your general attitude about collaborating with the enemy?
Sure. Well, you have to look at every case, and each case you get in, you want to see you're doing what's best for your insured. So whether that be strongly defending the product or trying to keep the total cost of claim at a lower number. And that's something that we're always keeping an eye towards, because total cost of claim, it affects not only the insurer, but it in fact affects the loss run of the insured, and that affects their premium when they go to get more insurance. So it's really, we have to talk to the insured at the beginning of the case and figure out what our strategy is. And if it is a strategy where we're looking at total cost of claim, then we can certainly start to look at some approaches that will allow us to get out of a case that don't have us spend $1 million in legal expenses, because as we all know, on an aviation case, it's rare to get a case all the way through trial without spending $1 million in legal fees. So we want to try and figure out what that best bet is. But as you said, Morgan, we need to also make sure that we're not hurting other insureds, which we try to do the Chinese wall and make sure that we're not having any discussions about that. But there's always someone. There's our global head of claims keeping an eye out, making sure that we keep those relationships, because you don't want to destroy the relationships amongst other defendants, even if you're not an insurer on their policy. So I think that you have to look at every situation uniquely, and it doesn't come up, I'd say, a lot, but when it does, and there's an opportunity for it, I think it really can be a beneficial way to, as we would kind of say, win a case without having to, get a defense verdict. So I think we keep an eye towards how that's going to impact our future litigation, because we do in this market see the same defendants in every case, it seems, especially in the products arena. And I'm working for insureds that supply their product to the same other clients. So you constantly see them. So you want to maintain that relationship as well, and try and, as Rick was saying, maybe give a heads up or talk to them through it, and just let them know that you're doing it because you have a duty to your insured to get the best deal for them that you can.
And Brian had mentioned that sometimes one or more defendants and the plaintiffs will reach some sort of tacit agreement about how to proceed in a case, maybe not vigorously contesting certain elements, or maybe kind of directing resources such as volumes of discovery requests and witnesses and that sort of thing at one particular defendant, as was the case in the KLA accident. And certainly we often see agreements between one defendant and a plaintiff where part of the deal is that the experts retained by that defendant are now out of the case altogether. And if you're the plaintiff, that might be a way of not only reaching a deal with a plaintiff with one defendant, but also ensuring that those experts don't then go to work for one of the other defendants in the case. So there's lots of different agreements that can be reached, but I wanted to turn attention now to the Mary Carter agreement, which is kind of the ultimate kind of nuclear bomb in this context.
By the way, can you hear us without the mic, or is it better if we use it? Can you hear me in the back without it? Okay, that's great. So again, before I answer the Mary Carter question, there's just one other thing I wanted to kind of cover, just so that we don't miss it. And that is, so I gave you the KL experience. By the way, I left out the most critical piece of information on that. At the end of the day, we understand that the government ended up paying 50-50 with KL, if you can believe that, in a case where their pilots flew a good airplane right into the hill. So, that was an odd set of circumstances. I want to talk to you more about the more typical ones that have happened, and then in one of them, the case that Tracy and I recently resolved, the Mary Carter agreement was a part of it, so I can address it that way. So what typically happens in my experience, and Rick's right, there's generally, and we don't like this, and we like it even less with the way jurisdiction has now swung to make it harder for us to get everybody in one particular spot. And that's a topic for another day, maybe a whole day of conversation. But you add that to the other risks and concerns a plaintiff would have about leaving anybody out or letting anybody out early, and we are talking about rare situations. KLA to 1 was rare, really rare, and even these other ones that I'm about to tell you about, I think, while typical, don't happen that often. But there are some where it really makes sense, and the risks are less dire for the plaintiff's lawyer. So it's something you really should think about and maybe even be the initiating party. So for example, a lot of cases where you've got a pilot defendant, an owner defendant, an operator defendant, or maybe even a small-time maintenance defendant. Somebody who's probably maybe not insured or underinsured, which unfortunately we see a lot. Those $100,000 policy cases, we see them all the time. So the best thing that you can do is, oftentimes take the money and run. If there's no assets behind the policies, especially true, right? And in a lot of cases, you can take the money, cut that tail, and run. And then you can just proceed against whoever it is, the deep pockets, the manufacturers in most cases, right? But there are a lot of times when you can't get that cutting of the tail. You can't achieve a good faith settlement that gets that person all the way out. And so you have, at a minimum, a lot of tails potentially, but most often the contribution tail that keeps that settling defendant in the mix, spending money and exposed. So that's where Mary Carter's really come in, and I'll talk about it in a second. But those are the types of cases where we'll typically see it, where they're underinsured. The other dynamic is, well, okay, maybe they have good insurance, but liability is clear. Say you got $1 million policy on a pilot, and it looks like a clear pilot error case. Take the money, wrap it up if you can, but leave them in and prosecute the defendant if you can't. Maybe that defendant is the FAA, a la the 801 case. They didn't give a warning that they should have. They, put two planes together when they shouldn't have. They didn't provide enough weather information. Or maybe it's some technology in the cockpit that didn't warn the pilot or advise the pilot about what he got. You just get to take what you can and then direct your energies along with their help towards that third party. There's also some synergies there that are really important. You've now got the somewhat sympathetic, no longer with us pilot in your camp, right? You're still saving money, sharing resources. You control the litigation. You don't have some other entity out there prosecuting somebody that you don't want to prosecute, a less, well-insured entity, as you will, or a less deep pocket entity. So these are the kinds of things that typically pop up. So it can be something where there's clear liability, that's a reason to get them out. There's a lack of insurance, that's a reason to get them out. Or you may have a situation, put the pilot aside for a second, you have that innocent passenger, you have a well-insured carrier, let's say, owner, operator, okay? And they're minimally responsible. You still might want to take as much of that money as possible and then join forces to go after that manufacturing defendant. And there's one other part of the triangle that I think is really important to process. And to me, it, in my experience at least, it is what drives these strange relationships to occur. And that is, as you would absolutely expect, manufacturers dig in. Manufacturers defend their products vigorously. Manufacturers start with we are not going to pay, even if the defect is staring them in the face. And so that always gives you the time and opportunity to see if you can put a couple more rounds in the magazine to load up against those manufacturers by getting together with either another defendant that settles, or even in some cases, a potential plaintiff in its own right to get that deal to work, to go against them. So that's the more typical situations, and that was exactly the case that Tracy and I dealt with, except in that case there were two added things that I want to mention. One was the settling defendant, which was Tracy's client, had probably, had an equivalent level of anger about what happened and had a strong emotional desire to pursue the manufacturer. It was a familial effort. Her defendant was her insured was a $1 billion+ company at the end of the day. But the people that ran the company were my clients, in effect. And so the objectives were the same, and they wanted someone to pay a price. And the other thing that was at the bottom of this was the desire to exonerate. This was a case where the NTSB, no offense, David, does what they usually do, which is blame the pilot, in a case that we really believed the pilot was not to blame. And in particular, it was a case where they actually tried to blame some passengers for contributing to or even causing this chain of events of pilot error. And we thought it was something completely different, so we went to war. But in this case, we had a defendant that not only had a relationship with us, although it was at arm's length, but also had the same emotional attachment to exonerating the pilot, exonerating the family, and frankly, exonerating their company. So that's a wild card that, again, you never know if it's going to pop up. The last thing that we did was what Morgan brought up, and that is we did all this in the context of a Mary Carter agreement. And all I want to say about that, I think everyone probably knows what they are, although the more I practice, the more I realize they're very, very rare. First of all, they're flat out prohibited in about, I think, 20 states. And there's probably only a half a dozen that really unambiguously allow Mary Carter agreements to be used. And by the way, a Mary Carter agreement is one where a plaintiff and a settling defendant, but not all the defendants obviously, come to an agreement where basically there's a guaranteed minimum for the plaintiff and maybe even a subsequent reduction of a payment for the defendant, but it's a reduction of their overall exposure. And for whatever reason, like the inability to get out of because of in a good faith settlement, they also stay in the litigation, thus creating the benefits that we've been talking about, sharing of experts, sharing of expenses, and so forth. So that's what a Mary Carter agreement does. And in our particular case, what was unique was we had kind of a non-refundable cost of entry, which was a floor number. And then, of course, we had our guaranteed minimum, which would be in place if we had been unable to recover from the manufacturer. And then the added thing that happened in that case, just to make it wildly unique, was at the end of the day, the pressure that we brought about as trial approached brought the manufacturer to the table, and then we were actually able to broker a completely different global deal, which benefited everybody. So that's what Mary Carter agreements are. The states that have them, that I see them most often, is of course California. Interestingly enough, they started, and the case Mary Carter is in Florida, where it is now strictly prohibited. And Arizona, of course, is another place in Illinois where you can get away with some form of that. The last thing about Mary Carter's is the courts really, and maybe properly, are very skeptical of such agreements. They tend to thwart rough justice in that you've got a defendant who may actually be the most culpable trying to deflect the truth by making this side deal, potentially secret side deal with the plaintiffs. What the courts have done to allay some of that concern in the states that allow it is to require the deal to be noticed before it's made, or to require at a minimum that the court be advised. And in some states, to include California, there's actually even a jury charge that can be given to the jury by the court saying, hey, this whole deal, we're going to tell you about it, and it may be an indication of bias by the settling defendant against the non-settling defendant. So that's Mary Carter's in a nutshell from plaintiff's perspective.
And obviously, as Brian said, they're rare. They don't happen often, but in this case, especially as an insurer, it gives me a unique position to be in because I have to set reserves on a case. And this way, I can set a reserve, and I know that reserve is not going to need to be changed, at least going up, because I've got my cap of, this is how much I'm going to owe, regardless of what our liability is. And so in the case Brian and I had, we had, a low and a high, and I knew what my cap was. And then it was interesting because then we were able to negotiate an actual settlement within that high-low. And so, it comes off that I look like a hero because I've got, now I can take all these reserves away that we had been putting there. And as an insurer, you always want your insurer, the adjuster that you're working for, to be able to come in with a number below their reserves. So you want to give them, that idea of what the case is worth so that they can then, get a settlement or a judgment or whatever below that, because that's how one of the metrics by which we look successful. So the high-low, while it doesn't happen often, can really give a good opportunity in that respect because you kind of know what your maximum exposure is, which is very rare to ever know what your maximum exposure is going to be.
So we know that Brian and Tracy have done Mary Carter agreements. How many other people in the room have done a Mary Carter? One, two. And how many people in the room or up here have had Mary Carters done to them as the non-settling defendant?
How about suspected them?
Or suspected Mary Carters?
I've suspected them in a lot of cases.
Ashby, was your agreement that you had mentioned that where you had agreed with one of the plaintiffs in your case, was that a Mary Carter, or what form did that agreement
No,
take?
that just, we all teed up in the one case. It was two defendants and the plaintiff all agreed to go after one entity. And actually that insurance company, that insurer was denying on behalf of, and all the defendants were kind of together. Not the same entity, but we were different entities, and to go after that one insurance policy because the insurance on the rest of it wasn't enough to take care of the multiple claims that we had.
Yeah, so we see some of the reasons that where these agreements take place, either a party is uninsured or has a relatively low level of insurance. And it can also happen in a circumstance where one of the defendants is just kind of dragging their feet, and the other defendants think that they have a reasonable idea of how liability should be divided and what the value of the claim is, but you're kind of being held hostage by one defendant, and that can kind of give an incentive for the other defendants to enter into these Mary Carter agreements. So let's say you've decided that in your particular case, a Mary Carter agreement makes sense. What are the considerations in terms of whether or not you make the first move? Because it's kind of awkward, because we're all used to kind of, again, being on the opposite side of the V and looking at it as kind of a war. And now all of a sudden you're reaching across the aisle, oftentimes kind of early in the litigation is when it would often make the most sense. But it seems like that would also come with some risk, because if the other side doesn't want to do it, then are you just kind of looking weak? Are you looking like you don't really have much of an interest in fighting or prosecuting those claims?
I think they happen kind of organically, more so than anything else. You know, you sort of, the case lends itself to it, and it's such a small community that we're in that, you know, the defense attorneys know usually the plaintiff's attorneys and have solid relationships with them. I mean, so you can kind of almost have it over a drink or something, you know, start to have that conversation and broach it without having to make it something formal that looks like you're weak in a case.
So you can just kind of feel them out and informally without making an absolute offer. Okay.
Usually the interests are just going to align naturally. You've got an indemnification claim as well as your adjuster's got a subrogation claim they want to make, and it just kind of lines itself up naturally that way.
If you're the defendant in a case and you suspect that a Mary Carter might be used against you, what can you do tactically or strategically to kind of guard against this? Do you reach out early on to try to form a joint defense agreement? And even if you do, is that really going to give you a level of protection that somebody's not going to leave the joint defense agreement and do a Mary Carter anyway?
Well, I'm not on the defense side, but I can tell you one thing that I know is an impediment to that is when you have the one defendant that simply is not in a position to settle their position, and this was our case that we had. I mean, in the cases that I've had, it's either been a function of limited insurance, so a real defendant with a real policy with real money, but with even more exposure above that. Okay, so they say, well, we need to manage that. So this kind of goes along with what Tracy's saying about setting your reserves, but also if you're the insured in that situation, you may be thinking about more. That is one situation where I think it's been the nucleus for the Mary Carter agreement or high-low. And the other is where you just have a defendant that is just completely dug in and won't budge, so that opportunity for defendants to come together and do what they normally do, which is pile on against the plaintiff, it doesn't come about. And so, you know, that's what I see, but I don't know what you can do to prevent it.
Well, I'm wondering too if you've ever seen it, and maybe not so much a Mary Carter agreement, but just any sort of side agreement. I think, Morgan, you and I kind of had this in a case, although we weren't working together. We had co-defendants in a case, but the plaintiffs had made a deal with one of the defendants, but they would not let them out of the case. They had sort of a handshake settlement because they wanted to keep jurisdiction where it was. And they needed to keep them in so we didn't remove it to federal court. And so it was, that I think kind of is just an offset of our conversation here, where you have plaintiffs and defendants working together saying, okay, well, we'll come up with this agreement, but we got to keep you in. Or even, and I just suspected this, I don't know if there's actually been agreements in these, but I found, and Brian, you may be able to speak to this, that sometimes it seems that plaintiffs reach settlements with defendants and then sort of work together behind the scenes when it's a very good defense trial attorney or something, and you're like, oh, maybe they were just trying to get them out of the trial, you know, and trying to, and using them, but having an agreement in place that, and then sort of working behind the scenes a lot.
I would just add that from the ethical perspective, as far as I can see, none of these agreements are privileged. You know, so if they're whatever, you know, to the extent, if a party, you know, were to become suspicious of something going on, or in fact that there was a deal struck, and you know, just like we on the defense side, you know, we generally try to keep our joint defense agreements to ourselves, but you know, under certain circumstances, we could be compelled to produce them. But if there is a Mary Carter or some agreement, or even or even emails evidencing that agreement, I think that they would in most cases be discoverable. And so if as part of a discovery request, one party would request communications between attorney and client, attorney and another defendant, to the defendant and the plaintiff. Now, I'm sorry, once you send something to the other side, it's not your work product, it's certainly not attorney-client privilege. So I think in most instances, it's gonna be fair game. So if you are really on the alert that this may be happening, you are not without recourse to standard discovery procedures to find out more, at least as far as I can see.
Yeah, but that doesn't mean that you will find out. I mean, that's part
No,
of,
well,
the
that's true
secret
too.
part of these things, I suppose, which is why Mary Carters have been prohibited and, in many jurisdictions. I mean, there's a concern that the court has, with the non-settling defendant, who in theory might be less culpable, getting railroaded, under these kind of circumstances. In addition, you're right that I can think of some arguments to try to protect those type of communications, but it could be discoverable. The other thing about Mary Carter's that I thought I mentioned was that, in almost all cases, you're required to give notice to the non-settling defendant or otherwise advise the court. So the secret is eventually disclosed. But, to Tracy's point, I think on jurisdiction, that kind of wink-wink might happen. Does happen from time to time, and maybe even more so now. The idea that, hey, we know what your coverage is, or we know what we need, or it's cost of defense, we'll take that down the road, but we need to keep you in for another 3 months, 6 months. I can appreciate that type of tactics and strategy, and I don't think there's anything wrong with that, frankly. I mean, it's all under the rubric of forum shopping, I suppose. But that's just one man's opinion. But on the other side of it, I can't actually think of a situation where we would, meaningfully give weight to, attorney X. Whether he's actually good, whatever that means, or just a pain in the ass. In my experience, which where's Catherine? Catherine and I can talk about the situation. We actually have this kind of a case where we've been cooperating and have continued to cooperate post-settlement in the case, and we're still going after another defendant. So in that way, where there's this relationship that we've been talking about. And but the other side knows and has known that's the point of what we're trying to do. And at the end of the day, what is the objective? It is simply to hopefully achieve justice, not even rough justice, actual justice, by bringing pressure to bear to get everybody to do what we more often than not can do, which is to resolve the claims in a way that makes sense amongst all the parties.
And I would just say that from a defense perspective, and we've definitely, I think many of us have experienced this, where the plaintiff's lawyer says, well, you only got a $100,000 policy. At the end of the day, that's all we want, but we can't let you out now for whatever reason. And this litigation is now going to go on for another year or two. How comfortable are we, telling our client, hey, we got a deal, nothing's in writing, but let's just keep a low profile, attend the depositions, don't make too much noise, and hope everything turns out okay. That's not very comforting, to the client, I think, and to the lawyer, because for all I know, my client could hit the lottery and suddenly have $100 million in assets, and all of a sudden he's looking a little better. So, so I'm thinking, just from the defense side, that I think you have to proceed with extreme caution. And I've had clients tell me, and I hate to be a CYA lawyer, but when a client tells me, we have an understanding, I don't want you to do much. I mean, I've had a client tell me, I was about to go to a deposition. It was a product liability case / maintenance case. The big issue, one we never see, is whether it was maintenance or the product. I know it's quite rare. And so I had a plan, and the client responded, well, that would be great if we were really defending this case, but, just don't make any noise that will anger the plaintiff. So, all right. And I said, well, just to confirm, you don't want me to do this. And again, being a bit of a CYA on that, but it is, I think it is a very delicate situation to be relying on an oral agreement, on a litigation. And I hate the phrase zealous advocacy, because I think a lot of lawyers take zealous advocacy to an extreme and become difficult and obnoxious, but we do have a job to do under the rules of ethics. Our client is still the insured, not the insurer. The insurer controls the defense, the standard tripartite relationship as defense counsel. But it is a little unsettling when you feel like you're a lawyer not doing their job because of some informal understanding.
How would you handle that situation, Tracy, when an insured is getting nervous that circumstances in the litigation might change, and you've talked this over with the defense counsel, you think that this tacit agreement makes a lot of sense in this case, but now we have a company that's getting a little bit nervous?
Well, unfortunately, we're put in this position often, especially in the state of Florida, because there's just so many airplanes flying around with $100,000 policies that, and if there's a death or anything like that, you're trying to negotiate for that policy limit, but they don't want that policy limit. They want more than that. They want to, they don't want the pilot or the owner of the aircraft or someone, if they're still around and they weren't the person that perished in the crash, they want them involved in the litigation too. They don't want to have to track them down. They don't want, right. So it makes it's a little bit like walking a tightrope with it, because you have to, do what's best for your insured at all times. Make sure that you're protecting their assets and everything, but you also want to try and get them out of the case when you can, and it just sometimes it's just not, you can't do it. So we're always recommending in those sorts of situations, you need to get personal counsel involved too, and really look at what may come of this, because we've tried, we've offered all the money we have, and we can't set a precedent by offering more. I mean, you can't just start paying above your policy limits for things. So, you offer your money and you defend them as much as you can, but it's a very difficult balancing act to try and figure out how to settle that, as well as not spend then $1 million in fees on a case that you can only spend $100,000 on. So each one has to be kind of looked at and figure out what's the best strategy that always keeps in mind that the insured is the client.
Now, considering that under certain circumstances, the best thing for both the insured and the insurer in a given scenario might be to enter into a Mary Carter agreement, I was thinking on the way over here that I don't think I've ever seen in claims handling guidelines for defense counsel to consider and report on the advisability of entering into a Mary Carter agreement. Is that in your claims handling guidelines, and should it be something that's in there?
Yeah, there's certainly nothing in there about that. We're, as I think I said earlier on, we're always looking at sort of total cost of claim, and certainly it varies by each insured, because as Brian said, when you get a manufacturer, they want to defend that product, and we support them in that decision to defend that product. So it really depends on each case, but you're always sort of keeping an mindset of, okay, if we can get out of this case and get an agreement for $50,000 instead of spending $1 million in defense costs, you talk to the insured and you explain to them why this makes sense just in the overall scheme of things. But there's nothing in obviously our guidelines. We expect our counsel to kind of always keep an eye towards settlement or creative solutions that may give us an opportunity to get out of the case, because each set of circumstances is so unique that you're hoping that they're constantly updating you and saying, well, had a conversation, think this may be an option, or recommend trying this. And we're always open to trying new things if it is working with the plaintiff. I mean, the one that Brian and I had together, we ended up having a subrogation action as well. For the cost of our aircraft. And so Brian and I shared experts in the case. We were able to pursue that action at the same time. We had settled on behalf of our insured, and we're then becoming the plaintiff in the case and teaming up and being able to cut our expenses by sharing expert costs. So we're always sort of looking for those creative solutions when they can.
And just one little change of subject. One thing that I've found that's an uncontroversial situation in which I end up cooperating with plaintiff's counsel a lot is trying to deal with liens. And that's something that really doesn't get anybody angry, because the reduction in the lien makes a settlement more appetizing. And so I've had a number of cases now where, and I don't know if this is the trend, where a comp carrier, it's actually getting, I can't believe I'm saying this, easier to negotiate with Medicare than workers' comp lately, at least in my experience. But I've had a lot of situations where the comp carrier would not budge on their lien, and these cases that are the smaller cases where it's the so-called attritional cases, where there's minimal liability and a massive lien, if you don't get that lien compromised, you're going nowhere. So I will very early on find out what the lien is. I'll talk to the plaintiff's counsel, figure out what we need to do with it, and then I might call my insurance carrier and have my adjuster call the comp carrier so that they can do a little insurer discussion, talk the same language, and see if they can make the comp carrier understand that something is better than nothing. And that's becoming increasingly common. And even though it's typically not within a power of subpoena or anything to get a comp carrier at a mediation or attending something, to the extent we can procure their attendance to get a case resolved, I find it extremely helpful. And it's something we work with the plaintiffs' firms all the time to try to get that lien down so that we can come up a number where both the lawyers and the clients still have something left over that's worth taking.
And we see it a lot now with the, another aviation insurer being involved for the subrogation of the aircraft. And unfortunately, that adds to the pot. I mean, I know, we were talking about making a bigger pot earlier and stuff. I mean, when you've got another insurer involved that's saying, well, I want part of that $1 million for the cost of my aircraft. And that can make it really be an impediment to settlement. So you have to have the plaintiff helping you out there and everything else, or even, the head of our insurance company calling the head of, X, Y, and Z insurance company to say, hey, we're not being able to get this case settled because of your property damage claim. What can we work out here? And so I think you have to kind of keep an eye towards that too, and it does lend itself to working with the plaintiff with that stuff as well.
Brian, with so many jurisdictions not recognizing Mary Carter agreements, and if you're in that state court, it just doesn't work to go that course of action. Is that something you look at in those cases where you actually do have a choice of jurisdiction? Do you actually try to put it in a state that would give you the flexibility to enter into a Mary Carter agreement? Or is it so rare that it's just one of those things that happens to be serendipitous, whether you're in one of those jurisdictions or not?
It's probably more the latter. It's more serendipitous. But, it is one of the many things that you're thinking about, and even more things lately that you have to think about when you're trying to determine all the places in which you can file and secure jurisdiction over as many of the defendants as possible. But Tracy and I were talking earlier about it's also not that hard to find a place though that you can work the deal through that probably does recognize in a favorable way the use of these type of deals. So I think if you realized it was a real likelihood, you'd probably increase that as an important factor in analyzing where you might lay claim. Otherwise, I think you just have to see where you end up and play it by ear. The final thoughts I wanted to give on just as a lawyer dealing with these kind of relationships in cases is and I mentioned some of the benefits, but I want to stress it because as Tracy was talking about the subrogation, I remember the depth of our working relationship. Two things that were amazing to me. I mean, this was a case that were multiple millions of dollars were spent in prosecution of this rogue manufacturer. And so the idea that we could split that was hugely beneficial to my clients, as you can well imagine, or share it, I should say. The second thing is, in all of these cases where it's happened, including 20 years ago in the 801 litigation, it's really fascinating as a plaintiff's lawyer to get into the tent to whatever degree and work with defense counsel in the prosecution. I've had about 6 of these or 8 of these over my career where it's been that intimate of a relationship where you really get to see how the defense lawyer's mind works and different strategies and tactics and they're figuring us out too, but it's an exceptional experience in that way. In our case, it was the closest working relationship I've ever had. The firm that we worked with, which were Tracy's lawyers, I mean, we lived in their offices for weeks. We shared our experts, we theorized, we were texting and emailing and everything.
Doesn't that just make your skin crawl?
It does. I know. I'm doing this purposely.
It's making me a little bit.
Yeah, but it was.
Still spraying Lysol there.
It was absolutely critical to success. It was absolutely critical to building the pressure we both needed to have to get millions and millions of dollars contributed by this rogue manufacturer. And in the end, every bit, as happy as I was for my clients, I'm very confident Tracy views this as an absolute win-win for her. I have to believe that's a star on your report card for coming in at less exposure, below the money that you set the reserve. So it really is an example of where if it happens, it's something that you have to be open-minded about and embrace it.
And I think it's gonna happen more so than it has in the past. I just think that with the enormous verdicts that are coming out in certain jurisdictions, that and also just to, you know, at some point that's gonna change. You know, I know at some point that it's not going to keep going in the direction it's going. So I think that these agreements, I think, are gonna play a lot into the defense as well as the plaintiffs eventually. You know, the defense to try and limit exposure, and if there is a turn, you know, the plaintiffs to try and at least get a minimum for their client going forward. So I do think that they're a trend that's going to come about more, especially with all these manufacturers and having to litigate cases in maybe 3 different jurisdictions. You may have one manufacturer, you know, settling out and helping out either behind the scenes or involved, you know, actively involved in the litigation, just to try and figure out creative ways to get the cases done.
Well, I think because of that though too, you're also going to see actual more written agreements between defendants, because more and more you get a plaintiff that's sued 10 of you and you get a phone call, hey, let me let you out for this nominal amount. Oh, by the way, I need all your experts. I need a barrier.
That's a good point.
Right. Now, with big cases these days, like more and more, we're doing focus groups. How do you focus group a Mary Carter? It's difficult enough to present a case in kind of a nutshell to a focus group. Has anyone actually done that, where you focus grouped a Mary Carter?
Brian did it in our case.
So in this same case, which was out in Arizona, we focus group / mock trialed the issues. So the jury in one of our panels was aware that they weren't aware of the full breadth of the Mary Carter in terms of its specifics, but they were aware of the cooperation between our parties in prosecution of the manufacturer. So we wanted to see if they would, you know, consider that to be a bias on anyone's behalf. Really more Tracy's clients than the plaintiffs. So we did try that, and you know, it was not. It was not really a factor at the end of the day. I think in this particular case, it was understandable to the juries why Tracy's clients would take the position that they did. There really was perfect synergy. This doesn't always happen, but in that particular case, there was perfect synergy between our respective clients, so that it made sense to the jury, and so they really hold that against us. Was my take on it.
Is anybody aware of any data that's research that's been done on jury verdicts, you know, in the context of a case involving a Mary Carter agreement? In a lot of jurisdictions, they have to be disclosed to the jury, or it's actually, somebody mentioned, it's actually part of the jury instruction. So there'd be a way to take those verdicts and compare it to other comparable cases without Mary Carter agreements and see how it really shakes out and to whose ultimate advantage you know, these agreements go in one direction or the other. Is anybody aware of that being done by anybody? I haven't seen it, and again, they're so rare, it might be hard to do.
Yeah, I think it'd be hard to process that.
I just would add that, you know, to the extent that they're enforceable, you know, sitting in your chair, you know, we're all about risk management. And, you know, a Mary Carter agreement where you know the full limits of your exposure, and all of a sudden a whole bunch of theoretical what-ifs become concrete ceilings is very, very significant. And even if that is somewhat high, it's still going to be, you know, better than what could happen, worst-case scenarios, but it's now a calculable, defined risk on the indemnity side that is rather rare.
And it also plays to both angles, because on the insurance side, as you said, we're managing that risk and we want to make sure. So it caps our exposure, but at the same time, you can fiercely defend your insured, which is what a lot of times they want. You know, they want to defend, they want a strong
You're still
defense.
pointing the finger.
Yeah, you're still pointing the finger, you're still defending them, and as staunchly as you can, but you've set a limit so that the insurance company knows what their ultimate exposure could be. So I think it benefits both in that respect.
Okay. Are there any questions? Does anybody have any questions or final thoughts? Ted, we have a minute left, so maybe we wrap up a minute early.
Thank you very much.
All right.